Yes, ma'am.
There
And
you
Your
are.
Honor, this is Amy Turnbull, the GAL.
Great.
And Casey Linney on behalf of the state, Your Honor.
Okay, thank you. And I apologize. Heidi, are you there?
Yes.
Oh, you're on the iPhone. Perfect. Okay. So what I saw was that you did meet with courthouse facilitators, and I do have orders. The courthouse facilitator had noted service needed to be made on Ms. Looney's office. Ms. Looney is here. So I don't have the proof of service yet. So I guess I'll first ask you if you've been served and what your anticipation is for today.
Your Honor, we were served with a copy of the proposed parenting plan with an attached declaration. I know previously when we were here, which was what necessitated the court facilitator meeting, was that the parents had already also asked for an adjustment on child support. So if they're still requesting that, we have not been served with those documents. If they're no longer requesting that, then we have our proposed order and we're ready to go forward with that regarding child support.
Okay. So let me turn to the parties. You heard what Ms. Looney had to say, and it's true. I don't have anything other than the final order on petition to change a parenting plan and the parenting plan that the courthouse facilitator reviewed with the attached declaration, which kind of clarifies some visitation. So I guess first I'll turn to you, Ms. Entler/Johnston. What is your position on your request today?
We can move forward.
Go ahead.
You can go ahead.
Are you requesting a change in child support?
No.
Okay. Mr. Entler, what is your position?
Move forward.
Okay. And then Ms. Looney, just so I'm clear, should I have an order on child support from your office?
Your Honor, we did send that over previously back in July, so I'm hoping it's still with the file. It should be there. We have a proposed final order. It was an amended order because we had a change in custody for the children after we had put in our first order. You should have one that shows that 3 of the children are with mom and 1 is with dad. And the order should be for mom to pay, I believe it's $178. I'm just double checking that, Your Honor.
Okay. And I don't have the hard copy, I'm sure, because it's been so many months, it just didn't make its way to me. I'm sure we have it. I'm just going to look in the digital file and I can approve it that way. And then I might just have your office email a new one over.
We can definitely do that, Your Honor. I apologize for that not being with the file today.
Okay.
We could have sent a new one, but we apparently didn't get that completed in time.
No problem. Is it the 7/20/23 amended proposed orders?
Yes, it should be.
And that one does have 178 total child support.
Yes, that should be the correct one.
Okay. So to the parties, have both of you reviewed that child support order?
I have, yes.
And you both are in agreement with that?
Yeah, we went over the paperwork over something. We agreed to everything that was on there. So,
okay. So anything else the parties want me to decide on before I sign these orders that you reviewed with the courthouse facilitator?
No, Your Honor.
Okay, thank you. I have reviewed those documents. I am signing them. I appreciate you working with the courthouse facilitator to get those done. I appreciate your work on reviewing and agreeing to the state's child support order. I should ask Ms. Turnbull whether you had any further input. I apologize.
No, I'm in agreement.
Okay, so I've signed the final order and findings on petition to change the parenting plan. I have signed the new parenting plan. I have reviewed digitally the state's proposed amended orders. And as soon as Ms. Looney, your office emails those to Sylvia, I'll get those signed and filed.
We will do that today, Your Honor. Thank you.
Francisco, can you go ahead and mute until your case is called?
Oh, sorry.
Nope, you're fine. I'll hand those to the court. Okay, anything else from the parties on that matter?
No, Your Honor, that's it.
Okay.
No, thank you, Your Honor.
Thank you.
Your Honor, may I be discharged from this case then?
Yes, yes. Thank you for your work.
Thank you.
Good morning.
Good morning.
Good morning. And I think the state of Washington might also be on this case unless I am mistaken.
We were previously, Your Honor, but we're no longer involved.
Okay, that is the note I had, that you all withdrew, but I think the parties still did serve your office just to make sure that there wasn't going to be re-involvement. Does that sound correct?
Yes, ma'am.
Okay. And then the notes I do have, let me just pull up your digital files. I did get the confirmation of service on Ms. Height and on Division of Child Support. So thank you for doing that. I have the certificate from the courthouse facilitator, just noting the only requirement that you still needed to do was those two service options. Ms. Height, any input on these agreed orders?
No, Your Honor. Thank you.
Okay. And I'll turn it over to the parties. Is there anything, I did not see any places of disagreement that you're asking me to rule on, but please let me know if I'm mistaken. Otherwise, I will sign these orders as presented.
I just basically filled those out to follow all the commissioners and the guardian middle items recommendations. So that's basically everything that's already set out. She knows that she has to file the motion to petition for visitation. So I guess agreements and everything would be based on her.
And
So,
go ahead, Ms. Jones.
so I just graduated inpatient PPW. I was in there for 6 months. So what would my next steps be?
So I can't give you legal advice. So let me start with a question for you. Okay, Ms. Jones, I just first want to confirm, I see that you have signed these documents. It's the final order regarding parenting plan, residential schedule, and child support. And it's also the parenting plan and the child support worksheets. Are you still in agreement with these as presented?
So yeah, but I want, will I be able to change those? I'll be able to change those, right? Once I'm ready to, ask for visitation.
So again, I can't give you legal advice specific to your case. You may want to reach out. What are the days that we have legal aid here again? I always forget.
Mondays from 12 to 2.
Mondays from 12 to 2 here at the courthouse. We do have family law attorneys who can chat with you at no cost. So that would be my recommendation. There are ways, just generically, not your case specifically, but just generically, there are ways to modify parenting plans and visitation. But I want to be clear. I guess my question for you today is making sure you're in agreement with me signing these orders as presented based on your signature on them previously. And then subsequent to that, you can meet with legal aid and get some advice on modification when you are ready for that.
Okay.
So are you in agreement?
Yes.
Okay. I have signed these orders. Mr. Voorhees, thank you for meeting with the courthouse facilitator and being so diligent and getting all the service processes done. I know sometimes it's clear as mud, so I appreciate you doing that. Anything else from the parties today?
No, ma'am. So just basically for her, let's go in there Monday from 12 to 2 so she can get that information.
Yeah, if she wants to, at the point when she's at a place in, rehabbing, that she wants to just open up visitation options, I would suggest she meet with legal aid. She doesn't have to. I mean, the two of you can certainly work on it together. But if Ms. Jones, if you're doing it on your own, that is an option for you to meet with legal aid at no cost to you.
Okay.
Okay.
Okay, thank you.
Yes. And Ms. Height, you, similar to the prior case, would you want to present an order for discharge that I will approve, or do you want me to prepare that?
I'll prepare that, Your Honor. Thank you very much.
Okay, thank you. There are those orders. This courtroom's a little harder to hand things to you.
I'm sorry, Your Honor.
Yep.
So can Tyler let me see Sophia on his time if he feels like he can? Like, is he able to do that? No.
The two of you can chat about that outside of court, and then if you need court involvement, either one of you can bring that back.
Okay.
Okay. Thank you. On this case
Thank you
as
so much.
well. You're welcome.
Yes, Your
You're
Honor.
both free to log out. And I do on this one have your office's child support order and worksheets. So let me see. Do I have Mr. Sunderland?
Yes, I'm here.
Okay. And then Nicole Tomlinson. Mr. Sunderland, I think one of the comments was from the courthouse facilitator was to serve the motion docket on Nicole for today's hearing. And I don't have a proof of service for that. Can you tell me if that's been served on her?
No, it hasn't. She moved to Eugene, Oregon.
Okay.
And she is giving me custodial of Leah. She says that she's too sick right now to take care of her.
Okay.
And so she wants Leah to be with me. And we're talking about what we want to do next. Potentially modify the parenting plan so that she can, see Leo.
Okay, so a couple things. I mean, number one, since she hasn't been served with this, we can't go forward today. But it sounds also to me, and I'm just checking. So on the proposed order you've submitted thus far that you met with the facilitator on, she is the custodial parent, but with visitation with you, and you're telling me that that's going to change to you being primary.
Yeah, I've had Leah for the past 2.5 weeks straight, and Nicole actually packed up her stuff last night and left, and I let Leah say goodbye to her. And it's a big change. It was unexpected.
Okay.
And I'm just trying to help my daughter through this, knowing that she's not going to be able to see her mom very often.
Understood. So it sounds to me like you would need to renote this with new orders. And obviously if the custodial parent is changing, you're going to have to go through the same process, meeting with courthouse facilitator again, and then serving Ms. Looney's office as well, because I'm assuming probably with good reason that could change the state's orders.
Yeah.
So I can give you a new date to kind of set a hopeful deadline for you to get those things done, or you could simply renote it after you meet with the courthouse facilitator. So taking into account that you have a lot of change in your life right now, it might be best just for you to renote it when you're ready.
Okay.
Does that work for you? Ms. Looney, does that work okay for you?
It does at this time, Your Honor.
Okay. So what I'm going to do, Mr. Sunderland, is just strike today's hearing, just noting that you're not ready to move forward and Ms. Tomlinson has not been served anyway or isn't present today. Right. And then when you are ready for the court to re-review the new proposed parenting plan, we go ahead and renote it after you've met with the courthouse facilitator and served Ms. Looney's office, okay?
Okay.
But thank you for doing all the steps thus far.
Hello, Your Honor.
Yeah,
hello,
you,
good morning.
Okay.
Best of luck to you.
Hello, Your Honor.
Good morning, Mr. Llewellyn, and good morning, Mr. Lawrence.
Morning.
So what I have us on for, I have us on for a review hearing, but I also have us on for an adequate cause motion that Mr. Llewellyn has filed since our last appearance. And I'm just going to open up our digital file here. And what I have is the Mr. Llewellyn's proposal or motion for adequate cause and a proposed new parenting plan. I did receive, Ms. Burkett, your response, so thank you for getting that in. I also see that it was served on Mr. Llewellyn October 27th. Mr. Llewellyn, have you received the response to your motion?
I have, Your Honor.
Okay. Do you need any additional time to respond or review that response?
I didn't know that I needed to respond. I thought that was just her response, and then we had our court date. Was I in need of doing so?
Well, I'm asking you if it was just served on you just a couple days ago. So I'm asking if you're wanting any additional time to review or respond to the objection to your motion.
No, Your Honor.
Okay. And Mr. Lawrence, have you received the motions, the proposed parenting plan, and Ms. Burkett's response?
Yes, I have, Your Honor.
Okay. So we will take up the adequate cause hearing then. But first, I think I'll just ask for Mr. Lawrence's input on what's happened since our prior hearing to help kind of guide how I handle this case.
Your Honor, Shane has always tried to increase the amount of visitation that he has with his son, Abel. Tessana just recently got out of jail for her issue where she caused a car crash where she injured a couple of people while under the influence of alcohol and possibly marijuana. I'm going to kind of go back to the beginning of this and put it into some perspective. Tessana has always been fearful of Shane relapsing, and Shane does have a history of relapsing up until about 2 years ago. His medication wasn't properly dosed, and the medication that he had made him feel lethargic. He was also utilizing marijuana at the time. And then about 2 years ago, when he went to Core Health, they got him on a new medication, which has made him feel very good. And he's more than willing to take that. And he's been providing the court with copies of his dosing levels, and he is in compliance with the treatment that is being provided to him. And there's been no relapses over the last couple of years. What Tessana, I understand her concerns, but what she forgets is her behavior in all of this. And it was just a miracle that Abel was not with her during the time that she had her car crash. So she's not a totally safe parent either. And so where we're at in this situation is when Shane undergoes a manic phase due to his bipolar disorder, he does not recognize when he is starting to go into it. However, those around him notice it quite distinctly. It doesn't just happen like a flip of a switch. It takes a little time for it to develop. Also, I have some concerns that Shane, being a person with a disability and who has followed the court's orders over the last couple of years and has, for all intents and purposes, been stable, that I'm concerned that continuing to put him through unnecessary hoops may be a violation of his civil rights. And I have reached out to an Americans with Disabilities coordinator through the Federal Department of Justice, and I'm going to be speaking with her this afternoon. And I want to see whether we're skirting with any issues of civil rights violations by continuing to try to throw roadblocks in front of Shane's visits.
Mm-hmm.
At this point, what I would recommend to the court is the supervised visits. First of all, were through reconnecting families, and that became a financial hardship for Shane. Then he had Ms. Woodage providing the supervision, and she did not want to supervise them to the level that Shane needed. And so that fell apart.
Mm-hmm.
At this stage of the game, what I'm recommending to the court is to consider every other weekend day visits only, from like 10 to 4 or 10 to 6. When Shane picks up or somebody delivers Abel, they can assess, because everybody in the family knows Shane, whether or not he is off balance. And if that is the case, then he needs to be willing to then go seek his medical provider out and to get his medication adjusted. But if he is fine, then he should be able to have a day visit only for both Saturday and Sunday over a period of time. And I don't know how long that might be, three months or so, before we consider whether overnight visits should be allowed. But I think Shane should have to provide his medication compliance to Tess on a regular basis. I don't know if that's quarterly or monthly or whatever, but Tess also needs to be able to provide to Shane her treatment compliance for her substance abuse issues. Because at this point, her situation is more acute than Shane's at this point. And so that would be my input, Your Honor.
I very much appreciate that. So first, what I'm going to do, Mr. Llewellyn, as it pertains to your motion for adequate cause to change a parenting plan, I just first want to hear from you if there's anything you want to say in addition to your motion or based on what Mr. Lawrence has said to the court today.
So yes, I would like to say that the times that I had been manic was when I had smoked weed. I would go a long time without smoking and I'd think, oh, I'm fine. And then I'd smoke again and it would just right then and there, it set me off. And I no longer have any desire to smoke. And I am taking double the amount of medication that I'm supposed to. My brain is fully saturated. I asked to raise even higher. And my med prescriber said that that's for people with epilepsy. So I'm kind of a statistic for her with the amount of medication that I take compared to 30 or 40 of her other clients. And like I say, I'm not going to smoke anymore. And that was my onsets for episodes pretty much every single time.
Okay. How often are you seeing your provider for medication management?
So I was seeing her once a month, but she had said that since I'm doing so well and in compliance fully and my UAs are good and I'm on time to all of my visits, she said that we can go to every 3 months, but if it puts Tessana's mind at ease, I'm willing to go back to monthly. That doesn't bother me. As well as the other thing I wanted to add is Keith had said every other weekend, no overnight stays. That way during the pickups and drop-offs, people can see if I'm mentally stable. Due to the fact that I no longer smoke weed, I was able to get into an Oxford house. I have my own room here, and there are many people who know me and have known me for about a half a year now, and they are willing to allow my son to stay in my room with me. I have a giant king-size bed. Again, it's a room of my own. They all know me. They monitor me, and obviously I'm in an Oxford house, so I can't use. I'd be kicked out, and like I say, I have zero desire to use. So I see personally no reason to not get overnight stays, but obviously that's what we're talking about here.
Okay. And how often are you doing the UAs?
That's what it was once a month, but my med prescriber switched it to once every 3 months.
Oh, so your medication management and the UAs are every 3 months now?
Yes, Your Honor.
Okay.
I can switch back to once a month if that's preferred.
Okay. And then the Oxford house, I have had this come up in some other cases, and some of them have been open to having children there. Some aren't. You're saying that your Oxford house does allow for that, but there wouldn't be a separate bed or bedroom for child. Is that right?
Correct. They don't allow like full time, which obviously that's not what I'm getting, but every other weekend they are fine with. And like I say, I do have a king size bed and it's a room of my own. It's a very nice room. It's downstairs, secluded from everyone else. And there's actually 2 giant yards. There's one giant yard up top and there's one giant yard down below. And it's in a safe part, tucked away from like really even the street. And there's no neighborhoods around for any kind of, bad activity to go on around him.
Okay.
So I'm in a good place in life and where I'm currently staying.
And then you're working during the week, is that right?
Yes, Your Honor. My schedule just switched to 10 to 6:30. I was 11 to 7:30, but seeing as how I'm outside year round doing door sales, they switched the hours because of light time. We're losing out on light time.
And you have the weekend days off of work, is that right?
Yes, Your Honor.
Okay. Mr. Lawrence, any additional input? And then Tessana, I'll come to you based on the living situation in the Oxford house.
I was not aware that Mr. Llewellyn was in an Oxford house. I would have concerns about overnight visits there, but as far as day visits, I think it's fine.
Yeah. And I tend to agree that I wouldn't at this point be comfortable with overnights with the Oxford House living situation. But I do believe, Mr. Llewellyn, that the fact that you are there gives me some additional security ideas that there are folks who see you every day. So that if there was an episode that was perhaps coming up, I think you have some additional kind of safety in place for that. So I think that is good. Ms. Burkett,
Your Honor, may I say something super quickly?
Sure, go ahead.
So there is one other person that has their child here on occasion, and they do stay overnight. And I get that's probably a different situation than ours, but everyone in this house has been here for 6+ months. And like I say, I don't see how it's an unsafe environment, because if anyone does use again, they get kicked out. So they're very safe people. I've known them for a long time. I'm monitored well. I agree.
I understand. Ms. Burkett, what do you want the court to know in addition to what you have filed as your objection?
I also was not aware of the Oxford House situation. I don't know much about Oxford homes, so I'll have to look into that a little bit. As far as my sobriety, I have been sober for over 2 years from both alcohol and marijuana. And I also get tested for that regularly, at least a few times a month. So that was a one-time thing. Totally unfortunate and completely my fault, but was a one-time thing. And Abel is very happy here. He does love seeing his father. I do hope that they can continue that connection. It does just worry me about the relapsing. But yeah, that's about it.
Okay. And then how often are you doing any sort of substance abuse check-ins, appointments, UAs, that sort of thing?
So I check in with my DOC officer. I call her every day, but we meet up in person once a week currently. I get tested once a week as well. And I also see a counselor. It's not to do with drugs or alcohol, but I see my counselor twice a month, just for regular mental health check-ins. I also a drug and alcohol evaluation scheduled for Monday. And I had a hair follicle test done as well that came back clean. So, and I can file as well.
Okay, sorry to cut you off. Did the once a week testing you do, is that a UA or is that hair follicle?
It's a mouth swab that she does.
Okay. And what does that test for?
It tests for pretty much everything. THC, methamphetamines, cocaine, any kind of drug that I've ever heard of, pretty much.
And is there any specific testing for alcohol that you're doing?
That was not on the list, no.
Okay. The incident that you had that led to your sentence, was that alcohol related or other substance related?
Alcohol and marijuana.
Okay. Okay. Mr. Lawrence, any input from you based on what you've heard from both parties?
I'm pleased to hear that Tasana has been clean as long as she has. I think both of these folks really love their son and want the best for him. And right now is kind of a turbulent time. Shane appears to be have found the combination to keep him stable. And Tasana, if she follows through with her program, should be stable as well. And I would hope that all of this would lead to a wonderful relationship between Abel and both parents. But at some point, we can't be stuck in the past and need to move forward on this.
Yeah, I agree. Here's what I'm going to do today. I am, first of all, Mr. Llewellyn, going to grant your motion for adequate cause. I think that there are enough findings and changes since your parenting plan was put into place, frankly, with both of you, that it does warrant another look by this court for what your parenting plan should look like. I am not going to rule on a formal parenting plan today, but I am going to file a bench order that changes visitation and certain requirements right now. And certainly, Mr. Lawrence, if your discussions with folks changes anything when we come back for our next review date, I'd certainly like to hear it. But what I'm proposing at this time in my bench order, my ruling will be that we are going to take off the requirement for supervised visitation. Visitation with ABLE will go unsupervised. It will be every other weekend. Mr. Llewellyn, if just until we do our next review date and see how this is going, I'm going to keep it daytime visits, and then we can revisit overnights. I do have some concern about the lack of a separate bed. I'd want to know more from Oxford House about that accommodation. But would you prefer 10 to 4 or 10 to 6?
10 to 6, Your Honor. That's what we've had. Well,
Okay.
I was supposed to have been getting.
Okay. So what I'll order is unsupervised visits every other weekend, ABLE with you, 10 to 6, Saturday and Sunday. I would like to have you do, and since you're willing and have offered it, I would like to go to once a month UAs/medication management and have that submitted to Mr. Lawrence and Ms. Burkett, just so we can monitor. I think that'll also be helpful for you when we come to re-review for overnights, if you're willing to do that. And it sounds like you are.
Yes, I am.
Okay. And then I do believe the other reason I'm granting the adequate cause motion is a change in circumstances with you, Ms. Burkett. I know it was very fortunate that your parents were around to help while you dealt with your legal issues. I do believe that the court, in setting the new parenting plan, does need to at least initially monitor your substance treatment. So I am going to have you, you said you have a drug and alcohol evaluation scheduled for next week?
Yeah.
Okay. I am going to make that a condition of this court's obligations. And when you get that done, please submit a copy of that to the GAL so that we can see completion of that. I'm going to indicate that another obligation will be that you follow whatever treatment recommendations the substance abuse counselor recommends for you. And then I would like you to file your either, I'll put in here, either the mouth swab that you're already doing, but my bigger concern is alcohol, since that seemed to be the factor in your legal issues. So if your DOC officer wants to add, UAs to that, or if you want to get those on your own, I'll also put a requirement of at least, much like Mr. Llewellyn, once a month, alcohol or hair follicle testing, where my primary concern is checking for THC and alcohol.
Your Honor, if I may interject.
Please do.
I was the former director of Longview Work Release, and I was a parole officer back in the day.
Okay.
The DOC offices, I believe, have a portable breathalyzer that would give alcohol readings, and it's possible when she goes in and sees her officer once a week that they might be able to just have her blow into the tube and get it right there.
Okay. So I'll put in my bench order some leeway because I understand, these things all cost money and it all starts to add up. So this does seem like a good compromise that if you want to check with your DOC officer and they can add an alcohol testing component to the mouth swab, I'm happy to accept that. And I'm not going to require weekly. I'm just going to require that once a month, just like I'm doing with Mr. Llewellyn.
Okay.
Okay. So anything else, and then we'll set a 3-month review date to see how all of this is going. Anything else the parties want me to consider or review before signing a bench order and the order granting adequate cause?
I'd like to ask something, Your Honor. If I didn't catch on to this, I apologize. But if I could get UAs from Tessana regularly as well, information about them.
Yes.
And then also, I'm willing to do literally anything and everything to get more time with him and the overnight stays. So if the king size bed is a problem, I will get rid of the king size bed and sleep on a queen size bed. I mean, a twin size bed, and get him a twin size bed. So we have separate bedding.
Okay.
I'm more than happy to do anything required.
Yeah, and I'm not saying that's the only reason that I'm not granting overnights right now. I just think given the history here, and I agree 100% with Mr. Lawrence, we can't dwell in the past, but I do have to take the past into account. I think some of the allegations when you do go into a bipolar episode were quite concerning for safety. And so, I want to be realistic about that and do what's in the best interest of the child. But I certainly understand you've put in your time. You're 2 years without an episode. That's highly commendable. Keep doing what you're doing. I mean, you will get there. So.
Thank you, Your Honor.
Your Honor, I have one last issue.
Yes.
Shane has asked me to sit in on a visit with him and Abel. And we're going into yet another review hearing, and I'm probably going to be, having interviews and reading documents from both parties. I'm asking the court to consider giving me more funds for this matter.
Yes, I do believe, given the unique circumstances in this case, I will grant our typical order would be an additional 10 hours on this case with the normal hourly billing. Does that feel sufficient to you?
Right now, I believe for county pay, it's $14.85 at $67.50 an hour or something like that.
Correct. Does that seem like it'll be enough?
That will be sufficient, Your Honor.
Okay. Would you be able just to submit an order to me granting that additional time and money, and I will happily get that signed for you? I think this case warrants that additional time and attention.
Yes, I will.
Okay. I will get that signed when it comes to me. Anything else from the parties?
I did have one thing.
Yes.
So there is a order in place in this case, which, if possible, I would like to continue having most of the time. However, when Shane does have Abel, I think it's important for him to be able to communicate with me during that time. He needs me to come pick him up, or if he needs me for any reason, I want Shane to know that during the time that he has Abel, it's perfectly okay for him to contact me about our son, if that's possible.
Okay. And I think that and you're talking about the restraining order that's been put into place.
Yes.
I'm just looking to see. You don't have a separate standalone civil protection order, is that correct? Is it just the one that was done under the family law case?
I believe so. Yeah.
Is what I would be inclined to do if the parties are in agreement. I'm just going all the way back to look for that. Is I would put in my bench order that I would allow electronic communication between the two parties. It would not be a violation of the restraining order. And I'm talking about text messaging mostly. The reason I would say that is the court can review it, Ms. Burkett, if you felt like the communication was inappropriate or harassing in any way. So rather than phone calls where Ms. Burkett could say, Shane said this to me and I thought it was harassing and I have no way to monitor that, that if during the visitation when Abel is with Shane would be allowed to text message electronically with you anything about child visitation, safety, or welfare.
Yes, that sounds great.
Okay, would that work for you, Mr. Llewellyn?
Yes, the only thing I am wondering is, I understand that during my visits we can text, but for the pickups and drop-offs, if that's something involved in the texts, seeing as how it's only during the visits, how does that go? How does that work for like interaction for pickup and drop-off if that's what we talk about during the text messages?
I'm not quite sure I follow your question. What I'm saying is how do you guys already coordinate? Do you have a third party that communicates with you about when they're coming?
Yes, Your Honor.
I would continue that because what I'm focused on is when Abel is with you, if there's a question you have about, what he likes or doesn't like, and you want to ask her, or something, or she wants to check in, or Abel saying he wants to talk to his mom. And so you're letting her know he wants to talk to her. Those are the types of things I would allow during the visits. So I think just keep doing what you're doing with regard to third party drop-offs. And again, we will revisit all of this in 3 months.
Yes, Your Honor. And I will keep it very minimal and only about Abel.
That's great. Yeah, I'm going to put in text messaging regarding visitation, circumstances, welfare, and safety of Abel. Obviously, if there's an emergency, use your best judgment. I mean, if he's being rushed to the ER, do what you need to do to let the other parent know. But for just kind of the basic 10 to 6 things, use text messaging.
Yes, Your Honor. And does that continue on the same schedule that it's been on? Or would that start this coming weekend? Or
let's talk about that. When's the last time you had Abel or saw Abel?
I got to see him on Saturday for, what was it? 6 hours?
Okay.
10 to 4 I was able to see him.
Okay.
But I would propose, I mean, it's entirely up to you guys and if Tess agrees, but since I had missed out on so much time with him, if we could switch it to this weekend and then every other weekend,
okay,
that'd be nice because I lost a lot of time with him.
Ms. Burkett, would you be willing to start this every other week visitation this coming weekend? Would that work for you?
We actually had some plans going this weekend. He has a play date with his cousins that he really doesn't want to miss. If it would be okay to stay on the same schedule we've been on, just because we do make plans.
Let's start it. What would be that date? So the every other weeks would start next weekend, November 11th. Okay.
That sounds great, Your Honor.
And then let's set the review date. I know our dockets.
9 a.m. on Wednesdays.
It is going to be 9 a.m. on Wednesday still. Okay. Perfect. So let's put you on Wednesday, February 7. Okay. Anything else the parties need from me? Otherwise, I appreciate both of you being so willing to do the things you need to do to move this forward and give Abel the most stable parenting situation he can. So thank you.
Thank you, Your Honor.
I'd like to thank everyone involved in the case.
Yes, thank you for your patience and work, Mr. Llewellyn. Mr. Lawrence, anything else from you?
No, Your Honor.
Okay, I will get that bench order signed. Okay, you're free to log out. Thank you.
Just last thing that I just thought of right now. Yeah. If you don't mind, can I hear Tessana's how she feels about the whole king size bed thing? I know you said that's not a giant issue, but it did ring a bell in your mind, so I'm wondering how she feels about that.
Why don't I let you chat with Mr. Lawrence about that? That's something that he could talk to the parties about before we come back on our review hearing.
Yes, Your Honor. Thank you so much.
All right. Thank you.
Thank you, Your Honor.
Thank you. Not seeing Mr. Utter with us. Ms. Young or Mr. Lawrence, when we were last together, I had signed the order for reunification counseling. I did put on hold future visitation until we got some indication about where we were at with that. And I don't have any updates in the file anyway.
So Kaiser doesn't offer it. So Stephen, and he reached out on his own, and I guess he did an intake. And he had sent Keith and myself an email. I believe it was on 10/16 that he was just waiting for a call back. I haven't heard anything since then. It's just kind of hard to find a counselor.
Yeah.
That's correct, Your Honor. I did receive an email from Mr. Utter indicating he had reached out to the counseling group of Charlotte Rosen. And I have the ultimate amount of respect for Charlotte's work. And I thought that was a good idea, but I don't know if it's actually occurred yet.
Okay. And since he's not here, and because that's essentially what we're waiting on, my proposal would be just setting a new hearing date.
Okay.
Ms. Young, what would work for you?
Any time is fine. I don't know how.
Yeah, I don't know how quickly this stuff happens either. Mr. Lawrence, any suggestions on timing for the next review?
I would suggest maybe 2 weeks. That should give us enough time.
Okay. Ms. Young, you kind of cut out there. Sorry, I think your audio cut out, so I thought you were done. But I'm proposing Wednesday, November 15th.
Okay.
at 9 a.m.
Okay.
And if someone is in touch with Mr. Utter, if they could let him know, his presence would be mandated and appreciated.
I will get a hold of him, Your Honor.
Okay, we'll see you back on November 15th. Sarah Finn with us.
Thank you, Your Honor.
Okay. Thank you.
Thank you.
He may have forgotten. Could I message him so we don't have to come back at another time and maybe get back to us?
Yeah, I don't see him online and I don't have anyone in the waiting room. So if you want to message and see if he's going to join us, then I'll come back to this matter as soon as I call another case. Don't think so. Okay. Well, Mr. Lawrence, then I am going to come back to you on the Gutierrez matter. Let's see if I have the parties present. I do have Francisco Gutierrez. If you want to go ahead and unmute.
I'm here as well.
Okay. And then is it Alyssa or Elisa?
Elisa.
Elisa. Okay. When we were last together, October 4th, I had set over any ruling. Oh, and we have Ms. Looney on this case too. Thank you. I had set over any ruling on the adequate cause motion because there was a concern, a pretty significant concern that Mr. Gutierrez, you weren't in compliance with any treatment. And there was a concern that you were declining treatment. I know we had a lot of discussions about what you would need to do in order to be compliant. Where I guess first, Mr. Gutierrez, I'll ask you about any updates with treatment.
I don't have to take any. I'm not on any treatment. So I'm not denying or refusing to take any treatment. There was a paper that I got from the counselor, and I submitted it to the court. I don't know if you got that paper.
I do see that October 13th that does confirm what you are saying, that it was determined you did not meet any criteria for an active substance abuse diagnosis. There was no recommendation for treatment and your UAs had all been negative. Is that your understanding?
Yeah.
Okay. Mr. Lawrence, any updates since our last court hearing on this?
Yes, Your Honor. If the court recalls, I had requested not only that he undergo an evaluation, but that there be input provided by Elisa and myself in that evaluation.
Mm-hmm.
I had a chance to speak with the counselor from Kaiser, and she was not interested in any input from me. I don't know whether or not she was interested in any input from Elisa. And I understand the technical aspect of this, that if he is refusing treatment, he's not ready, or they feel that he's not ready to be put into treatment, that he's not going voluntarily. And so her evaluation reflected that he didn't need treatment. And I think that is an error. I'm not a drug and alcohol counselor. However, in speaking with Elisa, all of the problems that have been generated in this matter have been the result of Julian's drinking. Their initial separation, the issues about the Memorial Day weekend fiasco. Ultimately, he ended up being I guess asked to leave his sister's home, and by his own admission to me, he is now floating between friends.
Can I say something about?
Sir, I'll come to you in a minute. Mr. Lawrence is speaking. I will ask for your input.
I think that the treatment is still necessary, and I would ask that the court not change the situation at this point until he actually gets into drug and alcohol treatment.
Mr. Gutierrez, I will come to you in a minute. Ms. Gutierrez, anything you want the court to know?
I feel the same as what Keith is saying. I don't feel that he's ready to have the kids alone because he won't get the help, and it continues. It's been going on for years, but he has been more consistently making his phone calls and reaching out to the kids. And I do feel like it would benefit them if they could get some visits, like in person. My aunt is more than willing for him to visit the kids with her presence. And he's done that before, and it was perfectly fine. So I would prefer that he starts getting some supervised visits because it's already been 4 months and the kids are struggling with it. I want him to stop drinking completely, but that's just been a struggle that I've fought with for a long time, and he doesn't want to do that.
Okay. A second, I'm just going back. This case has a long history that predates me, and I was just going back to check the bench order. I know you guys have been involved in this for a very long time. The prior commissioner initially hearing this case had specifically Mr. Gutierrez put in the bench order that when he suspended visitation, that did require the drug and alcohol evaluation with collateral input from the GAL and Ms. Gutierrez.
Yes.
And so I guess, Mr. Gutierrez, I'd like to hear from you. It sounds like the counselor that you did an intake with did not want to accept that type of input. So when you had your evaluation, was it you giving the historical information to the counselor, or what did that look like?
It was just a normal conversation. She asked me about my drinking. She asked me about any sort of use of any other drug, and I just talked to her about my, just had a conversation with her, and I told her, I let her know that she needed to put input with Alisa and Lawrence, and I mean, if whatever she said, we'll talk to them. I mean, that's out of my hands. It wasn't like I was telling her to say this to him or to Alisa. It was whatever conversation that had, I had nothing to do with it.
Mm-hmm. Ms. Gutierrez, were you able to speak with the substance abuse counselor?
No, nobody's reached out to me.
Okay.
I've tried to reach out to them to get some communication there, and they said that they couldn't communicate with me without his authorization. So
I told her, and I even emailed her, left voicemails to make sure that she gets a hold of Alisa and Lawrence. So I talked to her after, and she said that she emailed both of them and never got back to her. So I don't know. Maybe they're missing each other's emails, each other's phone calls. I don't know. And as far as my,
go ahead, Mr. Gutierrez.
I was gonna say, as far as my living situation, I'm currently staying with a friend because I can't afford a place of my own. I had to move out of my sister's place because I was paying her rent, and right around the same time to where I lost hours. I was trying to get a better schedule at work so that I can have the weekends off, so that I can hopefully get my visitation time back, and hopefully get a place of my own. But my hours went down. I do have a better schedule. I do have the weekends off. I just don't. I'm not working the 60 hours a week that I was working before. I'm cut back to 40 hours a week, and I can't afford, with the child support that was being taken out of my pay, and other additional fees and debt that I'm trying to keep up with. My pay. I don't have. Basically, I don't have an income. I barely have enough money to put gas in my car to go to work and back every day.
Okay, I'm gonna kind of switch gears a little bit and go to Ms. Looney on the child support issue. I did see the proposed orders. And so I'm trying to kind of make sense of, is the state requesting those be entered as final child support orders or contingent upon the adequate cause motion?
So, Your Honor, this case, as you say, does have kind of a lengthy history. So the reason that we have filed proposed final orders is that each parent has separately filed their own motions for adjustment of child support. Mom filed hers back in January. Dad just filed his back in September. So we have filed that proposed final order in response to those motions for adjustment that the parents are requesting. So we would think that at this time it would be appropriate to address final child support as that request has been made by both of them.
Okay. And the most recent proposed order I have is signed October 6, 2023. Is that the most recent one I should have?
Yes, Your Honor.
Okay. So and then that order, is that based on assuming visitation the parenting plan doesn't change currently?
Yes, Your Honor. We were using the information we have with the current child support or the current parenting plan, with the father not having that split at this time. We also were looking at the fact that the mother and children have recently been on TANF. We do have a notation in there that if TANF does become an issue again, that we would ask that those payments be the way that they were. I'm trying to find that on my page, but we're just asking at this point to address that child support. We have based that on Mr. Gutierrez's year-to-date income from a pay stub from September 15th that he filed. So that is where we got the information for his income that we used for our proposed order, where we have him at a gross monthly income of $67.31 and a net of $42.61.
So let me hear from the parties briefly on the proposed child support order from the court. So first from you, Ms. Gutierrez, have you reviewed the state's proposed child support order?
I'm fine with it. I didn't ever care to mess with it.
You didn't
So
want
whatever it takes. I didn't ever care to change it. He was the one that wanted to change it, but I'm okay with whatever they decide.
the current, and Ms. Looney, the current obligation, if this order is signed, would be for Mr. Gutierrez to pay $1,573 a month for all 5 kids total.
That's correct, Your Honor.
Okay.
That breaks down to $314.60 per child per month.
Okay. What's the current payment being made? Do you know?
It is
currently $1,240.
Yes, I was just looking in my file, and it is $1,240 at this point, Your Honor.
Okay. So, Mr. Gutierrez, what is your statement you want to make to the court about the proposed child support order from the state?
I don't know. I think it should be less, a lot less, so that I can afford to eat. I can afford to live. I can afford to get to work and back. I mean, instead of, it should be cut in half if you ask me. Instead of $300 per child, I mean, for me to be able to comfortably afford a place to live and a place to have, so that maybe whenever I get my visitation back, to have my kids with me, it should be cut in half, maybe like 150, 160 per child, just so I can get up on my feet and start getting my own place and start having a real visitation time with them.
Okay. Here's what I'm going to do, having reviewed the child support issue as well as the adequate cause motion from you, Mr. Gutierrez, to increase visitation. So first on the parenting plan / your request for 50-50 custody, I'm going to reserve ruling on that just until I am going to replace the requirement on you that whoever, whether it's your Kaiser substance abuse counselor or whether you need to go get a new one, the prior judicial officer's ruling that they had to accept input from GAL and from Elisa needs to happen. And the reason is very specific. So often in cases where perhaps, let's say criminal cases, where there's an allegation that someone has abused or is abusing alcohol, often we say, hey, get a substance abuse evaluation. The police report must be provided to the counselor. And the reason we do that is so that the recommendation is not just based on what the person is reporting to the counselor. I'm not saying that this is present in your case, but sometimes people will downplay their level of use of substances. And that's often a part of a substance use disorder. So in this case, because we don't necessarily have those other objective things for the counselor to look at, I am replacing the requirement that whoever does the evaluation that this court accepts must accept collateral input from the GAL and Elisa. And then at that point, I will reconsider your adequate cause motion. I hear Ms. Gutierrez stating that she wants supervised visitation between you and the kids. Is that something that you're open to currently, Mr. Gutierrez?
Yes, I would. The problem is, like I keep saying about my, as far as income goes, I mean, I can't afford to drive from Portland. I work by the Portland airport, and I can't afford to drive from Portland to Longview every day back. Well, not with the car that I'm driving right now. I can't afford that. It costs me like $100 every 4 days to do that. So, you know, as far as visitation, I mean, income is a big factor here for me. I'm really struggling with.
Okay.
It feels like I'm just working for nothing.
Okay. So it sounds like supervised visitation wouldn't be financially feasible for you right now.
I mean, I could work with that, but I mean, I would have to, I don't know, I guess use credit cards or something to be able to afford it.
Okay. What I'm going to put in my bench order is that, Mr. Lawrence, how would you typically word the supervised visitation allowance that we're going to do temporarily pending a substance abuse evaluation?
Well, that verbiage is fine. I would use the term that the supervisor be somebody that can be mutually agreed upon by the parties.
Okay. Do the two of you have a third party that you would both trust to do supervised visits?
The hours that he would be allowed to visit them while I'm still at work, they'd be with my aunt, who's also certified through the state to take care of them. And she's okay with that, and she's always been a mutual party.
And what's your aunt's name?
Sabrina Valencia.
And then when Ms. Gutierrez, do you want to put specific days and times on supervised visitation, or what is your request?
Monday through Friday is fine, and then he can see them after work until about 6 p.m. is when I get them from her.
So he could coordinate his visitation directly with Sabrina?
Yeah, she's totally fine with that. And I understand that he probably won't be able to make it every day. I just want it to be available for him so that if he can, he can.
Okay.
I know that his mom has mentioned that she's willing to help him if getting gas is an issue, she's willing to help him with that.
Okay. So that's what I'm going to do temporarily, Mr. Gutierrez, on visitation until we are able to get a substance abuse evaluation that meets the court's criteria. So I'll do a bench order to that effect. I am going to find adequate cause to modify or re-review the child support order based on the mutual parties' request. I do find the state's order as proposed comports with the income that the parties have reported. So I am signing that child support order today.
Your Honor,
oh,
we did leave in the, Your Honor, I apologize. We did leave in the deviation section because it appeared that Mr. Gutierrez may have additional information he wanted to share. I don't know if Your Honor wanted to ask you more questions about that. If you are going to decline granting a deviation, we would just ask that it be marked no and that there was no good reason to approve the deviation requested.
And I do see that on page 2, and I'm just looking to see.
It goes over to page 3 as well.
And into 3, okay. So, Mr. Gutierrez, you have indicated, so this new child support order based on your actual income from your pay stubs would put your total support obligation at $1,573 a month. You have asked, I believe that you are asking for the court to deviate from that standard calculation. Is that correct?
Yeah, I like I said, I think child support should be half that because
Why?
I need be like I keep saying. I mean, I would like to be able to afford a place, a 1 bedroom, a 2 bedroom, to live and have my kids over whenever I get my visitation time back.
Well,
So have my kids and
So what
you know.
what I'm specifically asking you though is about why you can't afford that money based on your income. Do you tell me about your other household expenses? Tell me about where your other money goes. What is it that causes you to tell me you can't afford $300 per kid?
Well, as of right now, before Lisa and I separated, she took it on herself to put 3 of my kids' phone on my phone plan. So I'm paying for 3. I have been paying for 3 of my kids' phones so that I can be in touch with them. Before Lisa and I separated, there was a personal loan for $5,000 that I took out for car repairs on the car that she kept, and I'm still having to pay on that too. And there's also
how much do you pay on that?
On the personal loan?
Yes.
It's $240.
Per month?
Yes.
Okay. Any other extraordinary debt that you're paying on?
There's credit cards that I have to use, and there's also I try to explain this to the child support people. There's also during the months of October, November, and December of 2022, I did not give Elisa a child support check because she was behind on bills. So instead of paying her the child support check, I paid the mortgage for those 3 months. So according to the child support Intel people, they don't care about that. So I'm still being charged for those 3 months for back child support when I pay the mortgage. I made the mortgage payment instead of paying Elisa child support check. So I'm still being charged for that back child support, and now I'm like between the cell phones, a personal loan, and credit cards. I'm struggling to keep up.
Okay. So I am declining to do any deviation. I find that $314 per child is exceedingly fair given your income. I think the other reasons you've given me are based on you essentially wanting it cut in half, which is not fair to the parent.
Well,
hold on, I'm not done with my ruling, sir. Which is not financially fair to the parent who is primarily supporting the children. But also the debts that you are discussing with me, I am finding were voluntarily incurred and not unexpected or extraordinary expenses. So I am signing the child support order as proposed by the state. I will have to do an order granting the adequate cause based on the request of the parties for that, and I will get that done today as well.
Okay, so
let's set a review date. I'm going to hand those. Let's set a review date for the adequate cause motion on the parenting plan. Certainly, how long, Mr. Gutierrez, do you think you will need to either get a new evaluation that will accept input from the GAL and Elisa, or talk to your Kaiser counselor about accepting that input?
So, can I ask something really quick about that? Do I need to go get a new counselor? Because that's gonna take more time if I need to go find a new
Yeah,
counselor.
if your Kaiser counselor won't accept the court's requirement that she or he take input from the GAL and from Elisa, then yes, you would need to get a new counselor or a new evaluation, excuse me.
I don't know. I
All right, then if you don't know, let's set this to December 13 at 9 a.m. if that works for you, Ms. Gutierrez and Mr. Lawrence.
Yes, it does. I just had one other question for you.
Go ahead.
Is there any way for me to be able to have any type of communication with him? Like, is there like an app that can be monitored? Because the state put in a protection order. He's not allowed to contact me because he was charged with domestic violence.
Right.
So right now it's like he can only call the kids' phones. And it's kind of hard.
For coordinating stuff about the kids?
Yeah.
Would Sabrina be willing to kind of be a go-between? I could put in my, well, let me rethink that. I might not be the proper venue for you to request that if you're telling me there's if there's a criminal no contact order in place.
Yeah.
You'll need to seek a modification that allows third-party contact through the prosecutor's office.
Okay.
Handling that case. So I would encourage you to do that.
Okay.
Okay. All right. So we'll see the parties back on December 13th at 9 a.m.
So,
all right. Thank you very much.
Yes, Mr. Gutierrez, I need to wrap this case up.
I'm just gonna, maybe a stupid question, but so you're gonna make my child support get higher, get out, like pay more, basically.
Yes, your child support obligation is $314 per kid. Yes.
Okay. That's
Okay.
great. Thank you.
You're welcome. We'll see you back on the 13th.
Thank you.
Thank you. Okay. I think I'll turn to you, Ms. Turnbull, first. I think when we set over this case because there was not payment or intake packets, so we really didn't have much to go on at that point. Where are we now?
Well, Your Honor, I still don't have any payment or intake packet from Mr. Serafin. Ms. Carroll has been making some payments. She has paid a little bit over 25% of her portion. I know she is struggling as she is currently unemployed. And I think she would appreciate if the court might consider, some relief on her part. But she has made an effort to contribute. I have interviewed Ms. Carroll. She has certainly returned her packet and made an effort, but I'm not sure what to do on Mr. Serafin's part as he has made no effort.
Okay. Ms. Carroll, I'll address you in just a second, but Mr. Serafin, in order to move forward, we appointed a guardian ad litem. You are required to engage with the guardian ad litem. What is happening?
I've just been really busy and exhausted, Your Honor. My daughter moved in with me. She's been going to fire science every morning, 7 in the morning. I'm taking her. She don't have her driver's license. She has her permit. I've been teaching her. And she just got work at Ridgefield. So I've been cutting my hours and work to fit her just so, she could have her career going. She just got done with school, so she goes to fire science in Kelso High. I just picked her up right now, and she's driving right now. And 3 o'clock, I got to take her to Ridgefield to work till midnight. I got to go and pick her up tonight. I just been busy, Your Honor. I just been, overwhelmed. But I'll probably today I will contact the guardian ad litem.
Ms. Carroll, let me just first ask just to make sure that it is still your request to move forward on an adequate cause hearing in this case to revisit the parenting plan.
Yes.
Okay. And then it sounds like you have made some payments, but now find yourself unemployed. Is that correct?
Yeah. I'm in the middle of applying for business license and getting that thing going. So in between jobs at this point. So.
Okay. And when did you end employment?
October 6th.
October 6th?
Yes, ma'am.
Okay. So yeah, I had signed our guardian ad litem order in August. And at that time, it was based on your income at the time. So what I will do is find at this point, let's do. And you said, Ms. Turnbull, she's paid about 25%.
Yeah, she's paid $500.
Okay. Let me do just a quick calculation here. I think we originally had her portion at 60%.
That sounds about right.
Which would be 1980. So there's about 1480 left. Miss Carol, is there any amount additional that you're able to pay? And I'm not asking for, the full amount originally ordered, but do you have any additional monies you expect to come in?
I don't right now. I just, I'm trying to get my feet on the ground with income coming in, but that took income to maintain. So I don't have any extra money at this point with bills, and I'm not receiving child support on time at all. So when it does come in, that's beneficial, but I don't have any extra money right now.
Okay, what I'm going to do just for now is indicate, I'll do a bench order. Where to go? That because of your current unemployment status, we'll go ahead and do $500 of your portion paid at county expense. And I'll just put due to unemployment since order entered. That will leave a portion payable by you depending on how many hours the guardian ad litem expends on this case. But I'll also indicate we will revisit petitioner's portion at next hearing.
Okay.
And that'll just be based on whether you are having income come in at that time.
Sure.
So I will do that. Unfortunately, it sounds like I will have to set a new review date for you because Mr. Serafin has not engaged with the GAL. So I'm just, sir, going to strongly encourage you to get that done as quickly as possible. I understand life gets busy. How much time do we think we need on this?
You're talking to me, Your Honor?
Yes.
I could get the paperwork done today and take care of that today, send it out, and
okay, could we set
I can meet her somewhere or her office somewhere.
Could we set this for November 29th at 9 a.m.?
That's fine with me. And Mr. Serafin, I would ask that you still return that to me, by the end of the week, and then we can move forward with the interview, and I can have more information to report back
to
the judge by the 29th.
Okay, thank you.
Okay.
Was that at 9 o'clock on the 29th?
Right. Thank you all. You're free to log out.
Thank you.
Thank you.
And then I'm just going to check in. Someone logged in under Kiwi Freedom Project. Can you let the court know your name?
Lakeisha Roselle.
And what case are you here for?
Just a second.
I think you might be in the wrong courtroom unless I'm missing your name on our docket. Let's see who we still have online. We are running out of time on this docket. Do I have any other GAL matters to be called this morning?
Your Honor, this is Christopher Zimmerman. I was under the impression that we were represented by a GAL now. I'm not sure if that's the case for this actual hearing.
Okay. Let me pull up your file. We did just recently appoint Ms. Corey, but her involvement, our review dates for that were starting November 15th. So okay. I'm just looking, just stick tight with me. We do have this on for a review hearing for November 1st to review the housing situation. So do we have Ms. Zimmerman on?
I'm here.
Okay. There you are. Okay. So we don't have a GAL with you today. That's on for first review 11:15. So much like you've heard from other cases, the more in touch you are with the GAL before the November 15th hearing, the more we can get done at that hearing.
Okay.
The reason we initially found adequate cause and embarked on this road to kind of reevaluate the parenting plan was because Ms. Zimmerman, your potential housing situation, as well as another adult in your home, that there were some potential concerns over. What can you tell the court about your current housing situation?
Well, first off, I never had another adult in my home. And second off, the place that I'm waiting on is actually being redone. And so I have decided to temporarily allow my children to stay with your dad until I get into the next place.
Okay. Well, and just to your first point, when we were here last, you indicated that there was another adult male staying with you.
I did not indicate that. It was indicated, and there was a situation to where another adult was at the house.
Okay. So I'm just reading from the minutes from Ms. Zimmerman at 10:10 responding to the court, quote, friend currently staying with her, end quote. So
in the garage.
So the person was staying with you, but in the garage. So you're making the distinction between.
Yeah, it was very temporarily.
Okay. Okay. So it doesn't sound like we need to do anything today if the children, Mr. Zimmerman, are temporarily with you. The point of today's review was to make sure that they did have a roof over their head, and it sounds like that is the case, correct?
Yes. I just was wanting to see about somehow getting something in writing, so that way I could apply for some food benefits just temporarily. But that's the importance is the children have a roof over their head. That is correct. It's important.
Okay. What I will do, and do you have both kids with you right now?
They're in school, but yes.
I don't mean right now, but I mean staying with you. Okay.
Yes.
So what I'll just do is indicate that minor children currently to reside with father, pending housing situation with mother, and further review of this court. And then you can get a copy of that order if you need it for benefits.
Okay, and also I'm just wanting to say this in the courts. I'm going to be talking to a few people that I know who are renters, and if something falls through, I'm going to try to help assist in Desiree finding a place. So that way we can make sure the kids don't get too affected by this, and they still have time with mom and everything and stuff like, just I want it to be less effective on the children.
I think that's helpful for your children. So I appreciate that. And then, so for the two of you, please get in contact with the GAL. We'll have you back November 15th, Wednesday at 9 a.m. with the GAL to talk about what the parenting plan should look like and where we're at with where kiddos need to reside / visit. We'll take that up in 2 weeks. Okay.
All right. And I think Desiree was trying to say something.
Ms. Zimmerman, did you have something to add?
Not at this time.
Okay, we'll see you back in 2 weeks. Please be in touch with the GAL.
All right, thank you.
So I was asking previously, someone logged in as Kiwi Freedom Project. You're connecting to audio. What case are you here for?
Thank you. I was having technical difficulties. Ozar Jackson.
Okay. And what is your role?
I'm community support, Mr. Jackson, with the Freedom Project.
Okay. And I guess I'm asking, what is your role in today's proceeding?
He asked me to support. I wasn't able to be there physically. So I'm here on Zoom to give support for him.
Okay. Then I had someone else just log in, Tanya Quinata. Can you tell me what case you're here on? If you just logged in and your name is Tanya, can you tell me what case you're here on? 808. I have this on for a modification hearing of child support and an adequate cause motion filed by you, sir, to change a parenting plan.
Yes.
I haven't yet seen a response from you, Ms. Stillwell. Are you planning to?
Yes, I was going to ask for extension. I have an appointment with the ESS, but they had an emergency and I was not able to get help with the paperwork and I needed help filling out paperwork.
Okay. And then I think I also saw one of my questions, sir, was whether you had served your proposal on the state with regard to child support.
Yes, they should have, oh, no, we did one service for everything. So the service that we gave you at the time was for all the paperwork.
Let's see, I'm just looking to see. I have the service on D Stillwell, but what I'm asking is whether.
No, I didn't serve it to the state.
Okay. Do any of the 4 children receive state benefits, including medical, TANF, anything like that?
I have state insurance for the children.
Okay. So we would need to have your proposal served on the state of Washington through the Cowlitz County Prosecutor's Office. So they have a chance to decide if they're going to be involved or not because of the receipt of state benefits. So let's give you all a new hearing date. This will give you, Ms. Stillwell, time to file your response. And then Mr. Butcher, if you can file your proposal on the prosecutor's office, we will have that moving forward.
Yeah, I will also need information on the state benefits because the kids have been getting medical treatment without any state medical assistance. I've been paying either out of pocket or just off our insurance.
Okay.
Because I have custodial and primary custody, and I did not know that they were still under her state insurance.
Okay.
And I also have insurance through work, and I've had insurance since the day they were born.
Okay, so you all figure that out before you come back to me.
Okay.
The state can help get you that information too. I'm thinking of setting you all to December 6th at 9 a.m. to give you time to get those served and get the response filed. Okay?
Yes.
December 6th at 9 a.m. will be your new hearing date.
Okay.
Okay.
So the plan is not changing until then?
Correct. I will be reserving on the adequate cause ruling, but you do have to file a response, ma'am, and there are time limits you have to do so. So
okay, I will have it done and turned in by December 6th.
Well, that's not what I'm saying. What I'm saying is there are time limits for you to respond after you've been served. Please review those and respond timely. December 6th is your next hearing date.
Okay.
All
yeah,
right.
I went to ESS to have an appointment to help with the paperwork.
That's fine. You know, if they had an emergency and couldn't help with it, it doesn't excuse your obligation to respond timely to being served with a motion to modify. So if you have objections, please read the rules and respond timely. Okay, we'll see you back all on December 6th. Thank you. Mr. Kamba, have you had any contact with Desiree?
Not at all.
Okay. Okay, so we're getting a lot of people joining this hearing in the last few minutes. If you're logged in as published writer, can you please tell me your name and what case you're here for? Okay, if you're logged in as Tanya Quinata, please tell me what case you are here for.
Elazar Jackson, Jackson versus Jackson. I'm just an observer.
Okay, and where are you observing from?
I'm observing from Cowlitz County.
Meaning, are you with an organization?
Yes, I am. I am a liaison for Washington Defenders Association for Northwest Justice Project.
Okay.
IMAP and several other coalitions, NAACP and Black Lives Matter.
And do you plan on, I'm trying to figure out, we've had a lot of people log in for Mr. Jackson in the last few minutes. Is someone representing, is Mr. Jackson represented for this proceeding?
We are just observing at this time.
Okay. Someone is logged in as published writer. Can you please let me know your name? You are logged in as published writer. The court cannot hear you. Please let me know what case you are here for. Mr. Kamba, we're going to come back to your case. I am not seeing Desiree Kamba. I have not seen her logged in since we started this docket at 9 a.m. I am looking for service.
She was served via mail. I don't have a return on the service.
Yeah, I'm not seeing any. I'm seeing your most recently filed declarations and your motion, but I'm not seeing your order to show cause for contempt is for the November 8th docket. You have one order to show cause that you filed for the October 1st docket, but I don't have any service indications on that one.
Yeah, she doesn't answer the door for anybody that I send to serve her.
Okay.
And that's why I tried to do the mail.
Yeah, so what you do need to do is whoever is trying to serve her, so you can't be the one to serve her. It has to be a disinterested third party over 18, someone unrelated to this case. You can have the sheriff's office do it, or you can have a process server do it. If they are unable to personally serve, they file that with this court stating they were unable to serve. That way, after you have tried to have her served personally, we can then approve service by mail or other alternative means. But today, hold on a second. So today I'm not able to move forward with your motion because I don't have proof of service on her and I don't have a proof of attempt of service on her.
So can I say something?
You can.
I've had maybe 4 different people try to serve her. She refuses to answer the door. Okay. I believe you denied her supposed me being in contempt and breaking a restraining order. She claims that I broke a restraining order, and then since last month, not October, but September, she hasn't let me see my son. And I just haven't seen my son this whole time.
Sir, hold on. You can, I will let you speak. The problem is I can't hear the substantive issues of your case if you haven't served her and she's not here. So I understand your concerns. What I'm telling you is I can't move forward with those concerns until you serve her and she has the opportunity to respond to your motion. So you're telling me that people have tried to serve her. They need to file affidavits of service or non-service with this court so that under penalty of perjury, I have a statement showing who tried to serve her, when they tried to serve her, and what they tried to serve her with. So what I'm going to do today is strike the 2 dockets that you have scheduled for today, and I'll have you renote those with the court and serve her. And then proof of service needs to be filed. If you can't personally serve her, you will need to file proof of mailing. I don't even have that.
So you said it's an affidavit something?
It's called an affidavit of service or a certificate of service.
Okay. So the people that have tried to serve her, they just have to fill that out and give the times and dates and that her car was in the driveway and all that stuff.
So I'm going to tell you, they do need to file with the court under penalty of perjury their attempts at service. If you are asking me to approve service in some other manner. Okay. So I'm going to strike your hearing for today. You can renote it with proper service. You're still on our docket for next week, and I don't have service of those documents either. Just a heads up.
That's with Desiree, correct?
Correct.
Okay, so am I gonna have to?
That's all I have time to tell you today. I can't move forward. I can't hear anything more about your case because the other party hasn't been given notice of today's hearing. Okay, so please make sure she is served, or that people file proof of inability to serve, and then renote this for a docket once that's occurred. Okay.
Okay.
Thank you. So help me understand, we have quite a few observers right now for this, and they're asking me questions about whether this is being recorded for the records of court. And I don't know what that means. So if you could help me understand what you are asking, I can respond. Are we all being recorded for our record? I still am not quite following the question, except to tell you that this is a docket that does have a court reporter, or excuse me, a court clerk. They are taking minutes. We also do record the live audio in the courtroom. It is available at a party's request to the Superior Court clerk. We also live stream these proceedings on YouTube as part of our open courts policy. Can I get a disclosure for this public record? I don't know what you are asking. If you are requesting a recording of this proceeding, you can do that through the Superior Court Clerk's office. So let me start with this. Mr. Jackson, let me just ask you, because you have several people who are indicating they are here observing on your behalf, on behalf of different and various organizations. Are you currently represented by an attorney in this matter?
No, Your Honor, I am not.
Okay. Are you proceeding on your own today?
I would like to get it set aside due to I am very ignorant to the law, so I can get an attorney.
So you said set aside. Do you mean, are you asking for a continuance so that you can speak to an attorney?
Yes, ma'am.
Okay. Because you have filed a motion to set aside a judgment that was previously entered against you when I believe you did have attorney representation. Does that sound correct to you?
Well, I didn't have attorney because he did not show up to court.
Well, okay. So there's a long history with your case, which is fair to say, correct?
Yes.
And when I look back at that history, certainly dockets that I was not a judicial officer on, I do see that you had an attorney who, whether you felt he represented you or not, did indicate to the court that he represented you. Is that fair to say?
That is fair.
Okay. And in reviewing your motion to vacate the judgment that was entered against you, that has formed the basis for Ms. Jackson's contempt motions, I do see that you're indicating one of your indications is irregularities in how you were represented by that attorney and what that attorney may or may not have told you about, informed you about, those sorts of things. Is that fair to say?
That is correct.
Okay. So then subsequent, and I'm just stating the history on the record so that if I am mistaken on anything, either party can jump in and tell me I am wrong. But what I also see is following that judgment and then Ms. Jackson's contempt motions and motions, I think both of you have filed motions to restrict abusive litigation.
I have not, Your Honor. I didn't
say that again.
I didn't file no litigation. That was their case. They started it. I did. I did a motion to vacate. The response on my motion, a response to the motion from them.
Okay, so you're not asking for an order restricting abusive litigation. You're responding only to his request.
That's correct, Your Honor.
Okay, thank you for that clarification. So going back to kind of my original train of thought, after Mr. Jackson, you started to believe you weren't being adequately represented by an attorney, and you claim that you recently came to find out that there was this judgment entered against you. then you have now filed for the motion to vacate that judgment alleging irregularities in the proceedings and other things. Is that fair to say?
Yes.
Okay. And then we have been here on prior dockets wherein Ms. Jackson's motions for contempt based on your, Mr. Jackson's failure to adhere to the judgment were heard before this court. We actually continued those to first hear your motion to vacate. Is everyone on the same page with me on that?
I think so, yeah. Yeah.
Yes.
Okay. And because obviously, if we vacate the judgment and order, then there's no grounds for contempt. But if we don't vacate the judgment and order, then we move forward on the contempt motions for Ms. Jackson. Is everyone still with me?
Yes.
Okay.
Yeah.
And Your Honor, the way how I saw it, they were trying to vacate the order from July 18th and from August, the beginning of August. So, I mean, this has been almost 4 months now. And so, yeah, I'm just like a little bit confused why they want to vacate that, because they haven't really done any of those things either that was requested by the court.
Correct. And I think the allegation at this point, ma'am, is that Mr. Jackson is alleging certain irregularities in the proceedings that he believes the civil rules would allow this court to consider vacating the prior orders. So what I'm hearing today, Mr. Jackson, is your request for a continuance of today's proceeding so that you can seek counsel to be represented in this motion to vacate. Is that correct?
Yes, ma'am.
Okay. How much time are you asking for to seek an attorney for that reason?
3 weeks. I just returned back to work, so I gotta
And
make time again.
And I do understand that you previously had some health issues that probably took your ability to seek counsel quickly away.
That is correct.
Okay.
Your Honor.
Hold on, I'll come to you in a second, Ms. Jackson. Mr. Jackson, just for purposes of deciding on your motion for continuance, do you have an appointment set up with an attorney currently, or are you still working on getting an appointment?
I'm still working on an appointment. I talked to one this morning.
Okay. Okay. Ms. Jackson, let me go to you. Mr. Jackson is requesting a 3-week continuance for purposes of being represented by an attorney in his motion to vacate. What is your opinion or your position on that? Are you in agreement or are you objecting?
So I'm objecting. So right now, my question is, Your Honor, with the
hold on, ma'am. I'm not answering your question. I'm asking you a question first. We will get to questions.
I'm not okay with it.
Okay, so you are objecting to a 3-week continuance. Can you tell the court why?
Because he kept on getting contingencies for the last few weeks. This is the third time that we're sitting here with the same case.
So that's not exactly correct. We've continued your contempt motions.
Yes.
His motion to vacate was set on this docket, and it had to be to allow him time to serve you so that you had notice of it. So what I did previously, you filed contempt motions. So
Yeah.
I continued those to today's date because
Okay.
this was the date set for his motion to vacate, which needs to be decided first. Okay.
Okay. I mean, he has so right now, what you're hearing, Tanya Granada, all this freedom, those are all, Tanya is his girlfriend. She's been filling out all his paperwork. She's been doing
Hold on, ma'am. Hold on.
Okay.
That's totally irrelevant to whether I find
Okay.
cause for the continuance. So kind of just sticking to the facts of the case.
I mean, we can continue on this one other 2 or 3 weeks.
Okay.
As long as my case is getting brought up too, right? Just as a question, Your Honor.
Yes. So
Yes. Okay.
if we continue his case for 3 weeks, we would what we call track your motions with that, because I need to decide the motion to vacate first before I decide your contempt motions. because your contempt motions are based on his underlying motion to vacate.
No, then I do not agree with it because I need to get back in my house.
Okay. Well, you're not in your house because of a separate and different protection order that isn't related to what's in front of me.
Okay.
You agree with that, correct?
I'm like a little bit confused right now, Your Honor, because we had the last 2 weeks, so this is the third week that we were talking about the issues of him hiding money, not letting me in the house, everything else.
Right. So, but hold on. So you're objecting to the continuance because you state you want to get back in the house. And I'm just having you tell me if you understand that the reason you're not in the house has to do with a protection order that is separate and apart from the motions in front of me in family law court. Do you understand that?
I understand that. And the judge had on 9/12 written that I get the house again awarded.
Okay. So I'm just going to focus. I understand there are other cases going on that impact your ability to get into the house. What I'm going to focus on today is whether I believe there's good cause for a continuance of 3 weeks on Mr. Jackson's motion to vacate judgment. What I am going to find is that there is good cause to continue this for a short period of time, which is just 3 weeks, to November 22 at 9 a.m. on this docket. And Mr. Jackson, it is my hope that I know attorneys are scheduled very far out. So it is my hope that you are able to get in with someone who can be present on that docket with you.
Thank you, Your Honor.
The reason I am granting the continuance is that I do understand the last 2 weeks, Mr. Jackson has had medical issues that have likely precluded him from seeking that counsel. I understand that there are unique legal issues that he is arguing regarding his prior counsel, and I am going to give him the opportunity for this first continuance request. This is his first continuance request on the motion to vacate. I am going to grant it. Further continuance requests might be denied or granted depending on the circumstances. And then what I'm going to do, Ms. Jackson, is track, meaning set over your contempt issues and Mr. Jackson's motion to restrict abusive litigation also to November 22 at 9 a.m. Are there any questions from the parties about what I have done today?
No, Your Honor.
I'm just like, right now, he returned the car to me. The car is not safe to drive. I mean, there's a lot of stuff that has been happening in 1 week. Like my dog died suddenly, which I'm assuming it was some kind of a drug. The next day, I see on Facebook, 2 of my other dogs are running loose through woodland. I still have no clue if they found back again or not. The strain that it has been taking on me emotionally and physically.
And ma'am, I guess I'm going to say, I understand you've addressed these concerns before. I understand, and I'm just going to go back so that you understand some of those issues are unrelated to this family law case, but more closely related to a separate protection order issue.
But
okay.
I haven't been in contact with him.
That is not what I'm saying. I'm not saying that you have violated a no contact order. I'm stating that the concerns you're bringing up, some of them do not relate to this family law case, but instead relate to a protection order issue.
Yeah, I understand that it's a protection, so it's a different case.
Correct.
So, yeah, I mean, why are we bringing it into this case?
Because you're bringing it into this case,
Okay.
ma'am. So I'm helping you understand why on this docket, I can't address all of the concerns you're raising. That is my point.
Okay. I had thought we would do this today since we moved it from last week to this week. So,
well, we did not move his motion to vacate. That was set for today.
Yeah.
So I'm going to grant a continuance. I'm going to issue a bench order finding good cause to do so through 11/22. Okay. So let me ask Mr. Jackson, do you have any questions for me before we see you back on November 22nd at 9 a.m.?
No, ma'am.
Okay. Ms. Jackson, do you have any questions for me before we see you back on November 22nd at 9 a.m.?
I guess not.
Okay. I do see, I believe on my, that'll show the end of my docket. Am I missing anyone? Okay, I see a lot of people online. I think you're probably all here as observers on our last case, but if there is someone whose case I haven't called, please state your name and what case you're here on now. Okay, hearing